You've just stepped into the undercurrent, where silence speaks, and the dead have stories, where trials twist, lies tangle, and justice waits in the dark. This is 12 Gauge, bent, not just reporting, relentless pursuit.
Homicide files, chalk lines fade, but the pain still breathes in the scars they made. Names on a flyer, tears on a post. We speak for the voices that need it the most. From alleyway blood to courtroom lies, we break it down raw, no suit, no disguise. Autopsy ink and ballistic threads, each theory we chase, every word they said. Crime don't sleep, and neither do we. Mic to the ground where the truth runs free. Learn, 12 gauge locked on the case, tracking the truth, no time to waste. From cold-blooded murder to trials on the stand, we dig through the dark with a mic in hand. Missing souls, addiction scars, forensics lit under justice stars. You want real? We speak that flame. Awareness, theory, remember the name. 12 gauge, we aim with truth. Late night reports, body cam rolls, whispers in courtroom, shattered parole, patterns in blood, a trace on the blade, every unsolved tale, yeah, we invade. The addicts.
All right. Happy Wednesday, everybody. I hope everybody's doing good. I'm broadcasting onto X and, of course, YouTube for the moment. My name is 12 Gauge, and this is my channel, 12 Gauge Investigative. You know, tonight I thought I'd hop on here and talk a little bit about just about anything. I really don't have a plan. I really don't know where the show is going, but I hope that we do have a good one and that we do have an interesting outcome to it. You know, this morning I went on to my channel and I did a live on the DoorDash driver and my thoughts and feelings about that. And I was able to just talk about how I felt about it. And I'll get on with that. But we do have some news in the true crime world. Karen Reed, obviously, found not guilty. And also, little baby Claire has been found alive. So that's a beautiful thing, is it not? It's always great when little children, elderly, women, guys are found alive. It's a beautiful thing. Because you know what? There's too many people that go missing every day in our world. So it's always wonderful that they're found alive. So I guess what I can do is I can go back into um, the hearing and we can watch it together, I guess. Because I did miss some of it. I didn't watch all of it. So, guess we can do that and then see where that leads us. Let me see if I can find one. It's not going to copyright me. Let's see. Did you guys get to watch the hearing today on any channels? Were you able to understand what was being said? Because there's a lot of people that just don't understand a lot of what's said in those hearings, and they automatically assume that other people that are talking about it are telling them the truth. Let me see if I can find it on Long Crime. I don't know if anybody. I think this is it. Okay, I'm not going to watch it on somebody else's channel because the first thing that'll happen is I'll get copyrighted. You know what I mean? I don't know if a lot of people. I know the reporter room showed it. Let's see. Like I said, I don't want to watch. I don't want to show it and somebody get upset and copyright me. Let's see. I know Kim and Carlos probably won't care if they showed it. Okay, she didn't stream it. Did anybody? Did anybody show it that I can? Let's see. I don't want to show that person's. Let me see. I want to do one without anybody else's commentary. Let me see. ABC. How's it going, Texas? Hope everything's going well for you. Rondi, I hope everything's going well for you as well. Um, hmm. Okay, here's one. This is the ABC one. So I guess we'll watch this one for a little bit. You guys that are on the sideline, come on in. Come on in. Let's go to court. Let's watch this. Okay, I didn't know Lean did. Jay did 12. Okay. Well, I found one, so hopefully this one will work.
Is the time set for, or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Brian Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically,
Okay, I forgot to say that fair use thing. Well, everything that I'm commenting on is due to my impression of this hearing, and it's covered by fair use, and it's being used for nothing other than educational value. So everything that I comment on this ABC hearing replay is done just for that. So here we go. And starts off first.
a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Koberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge.
Okay, let me start off by addressing the discovery, okay? I know that people think that she is still not getting discovery from the state. You know, whenever the state hands over discovery, in this case, they had a deadline. And they're not still handing over discovery. When she said, I just got discovery this week that I haven't gone over, I'm sure she meant that due to the people that are putting it in order, that's why she hasn't gone over it yet. Not that she hasn't gotten it from the state. The state had a limited time to give this discovery over, and they handed everything over by the deadline. So when she said, I barely got new discovery this week, that doesn't mean that she just got it from the state. It means that she just got it from whoever she has going through the discovery and putting it in order and everything that she's talking about. So, it's a play on words, obviously. It's a play on words, like what I talk about, the semantics.
Huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there.
Do y'all understand what I mean by that? It's not that they're not getting or have the discovery already. As she's speaking right now, they've yet to go through it and put it in any kind of order that's going to be usable in the trial. So it just to tell the judge, hey, we've yet to get the discovery. No, you have the discovery. You've yet to go through it, prioritize it, put it in some kind of order that you can present it to the court. So it's not that they don't have the discovery. Okay, so I want that to be clear to people, because many people hear that and they're like, see, the state still playing games. They still haven't given them all the discovery stuff, because as you've noticed, they have stopped with the motions for discovery. She has stopped. She said 23 motions that she did. So they haven't done any more because they got it all. They just haven't gone through it. So I want that to be clear with people, because people are misled by her wording.
There and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom,
Well, wasn't it them, the defense, that even filed for a change of venue? How can you file for a change of venue based on an unfair prejudice of your client not being able to get a fair or unprejudiced trial in Latah County? It gets granted to you. You go to Ada County, and then you're griping because you had to go through that when you're the one that asked for the change of venue. Did they not, chat? Am I wrong there? Does my memory fail me whenever I'm thinking back about the change of venue? Was it not the defense that asked for the change of venue due to, people potentially burning down the courthouse, storming the courthouse, and potentially beating up people and all this other stuff? Is that not what was said? That's one of the reasons why they wanted to change a venue. Just correct me if I'm wrong. It's cool. I'm not above being corrected.
we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to read.
So, chat, how do you feel while this is playing? I'm going to let it play, but as you know, I keep shutting it down because I don't want a copyright. I don't want the screen to go black, okay? How do you feel about the defense asking for more time? I've never really heard y'all's responses on that. If you could type that in the chat, that'd be awesome. I'd like to hear from you.
Review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. And the Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed. And that comes from State versus Creech, 105 Idaho 362 at 383.
I agree with your answer so far because, yes, he did say at the very end, prepare to go to trial on the date that was given. And also, it has been 2.5 years. You're right, Farah. You're right. 1 month and 23 days until trial. That is, you're not counting down, are you? You're not counting down. Good to see you. Good to see you.
Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. And effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524 said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F 3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation.
Can you imagine sitting there listening to this and knowing that the state has already addressed this? You know, knowing that the state has already sent a motion addressing this, and their document is more credible in the sense that it has different reasons why you should go to trial versus what they present. How even what she's presenting right now, the prosecution stands up there and rebuttals everything, and without reason. She doesn't give a very good presentation on the reasoning or how long they need for a continuance. Because I was thinking the same thing. I was thinking the same thing. Um, you have not given any reason as to how much time you need. What do y'all think? Am I right here? Did she not give any time frame?
In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Koberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Koberger's background has to be known and investigated and ready to.
Do y'all remember when I went over the state document where they were talking about they've gone to the Supreme Court and there's different cases where one of the cases says you're not supposed to, they don't want you to scour the earth for every little bit of life history before you go to trial. And I agree with you, Farrah. I really do. Why would Ann Taylor take on another death penalty case if she's having trouble meeting the deadlines for this one? I mean, she says she doesn't have a lot of time. Head of Christ, thank you so much for coming over from X. Good to see you. Anybody from X, feel free to come on in the chat. You're in a good place. You're in a good, safe place. So come on in and chat with us.
To present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase, and they rely on understanding family history and Mr. Koberger's own history. They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough.
So let me ask you, she's talking about being thorough on his life history. He was only 28 years old when he was arrested for this crime. how much life history does it take to go through somebody's 28 years? At least the first 5 is all about, birth, any kind of childhood issues, and then all the way up until 28. You're telling me it takes you more than 2.5 years to go through the life history? I don't fall for it at all.
That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation.
And you've heard me say countless times, there's nothing wrong with being thorough. It is a death penalty case. I get that. There's nothing wrong with them going to above and beyond, trying to find out if anything could set this man free when the trial comes. But at a particular time, when your attorney has a pattern of stalling and stalling and stalling, you have to speak up on this, because at this point, that's what it seems like. She hasn't mentioned any of this stuff. And they did the the last hearing where they were getting ready to go to trial. Nothing was stated about this. They were dropping the alternative suspect thing. They were dropping all this stuff just to stall. Do you believe that they actually have an alternative suspect? Do you believe that we're going to hear that this alternative suspect is somebody viable or something viable enough to turn the course of this? Or do you think or believe that we're going to go to trial?
They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Koberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Koberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333.
And if she's watching YouTube and speaking about who keep talking about it in a negative light, who keep talking about the Dateline episodes in a negative light, where it could potentially sway the jury's rendition of whether this guy was innocent or guilty. Do you believe that, honestly, people really sit around and talk about this case outside in the real world. Let me know how many of you actually have heard about this case in the last 2 weeks. How many of you have heard about the Dateline episode in the last 2 weeks? Has it continued to grow, or has it kind of died down? Because on these YouTube streets, I really don't hear a lot about anything until it drops some kind of video. The hot topic this week is the DoorDash driver, the friend of Brian's, whoever the hell he was, those type of things. How is that going to impact a jury, honestly? The green Elantra. How are those things actually going to impact a jury's mindset?
And a continuance may be the way that the court can best protect Mr. Koberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now, to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries, at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out.
Okay, so if Hunter and Emily, obviously that's who she's talking about, amongst others, actually participated in any of this stuff, are they going to represent anything that they already haven't got on record with the police, with the investigators? Because unless they go against their narrative that they gave to the police, then there's nothing wrong with them speaking on what they're talking about. How is that detrimental to his rights? I mean, it's a public right to be able to hear what this defendant is facing against him. We really haven't heard that much stuff. We hear it on YouTube secondhand, where we're forced to be getting different perspectives, not from the narrative of the news per se, but from YouTube channels who have an agenda to try to slander and manipulate the facts to be one-sided.
Out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Koberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
May I, Your Honor? Of course. Thank you, Your Honor. I will, I think, address Ms. Taylor's argument sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to.
I didn't watch Karen Reed, but based on some of the stuff on the first trial, I would have thought that it would have been harder to get a jury that hadn't heard about the first trial, but they were able to get a jury on the second trial And obviously, they did their civic duty today, and everything went along just fine, right? Unless that's not the outcome that you were looking for. Then that's your own personal issue, right? It's not necessarily the law problem how you feel about a case. The jury did their civic duty in the Karen Reed case today. And they've done it in the Delphi case, and they've done it in other cases. How they do their job, you do have an opinion about it, but doesn't mean that the law failed you. The jury system or the justice system failed you just based on your opinion on how you would have wanted the outcome to be different. Let's listen to this individual.
What might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction.
Leslie, to answer your question, I thought she was pregnant, so she may have had her baby. I don't know. I had heard that she was pregnant. I don't know if she was or not. This attorney is arguing counter against what the defense attorney just argued for. Obviously, the prosecution didn't want a continuance. He's talking about, how they're discussing certain things and how the state is counteracting that.
The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
Clerk needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a stand.
Yeah, that's what it's called, scorch the earth. That means like you don't scour the earth for every little bit, nook and cranny, hiding out, looking for every little piece of information about your defendant. I mean, it's honorable, but it's not necessary.
Standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial.
And that is true. He makes an interesting point there. It's not a checklist. It's not like, you know, if we go in this direction, checking these off, then we're meeting the legal criteria to go to trial. But it's not that way at all.
Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, there is no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors.
Yes, I mean, they've gone into detail. The judge was talking about this on the last hearing. These are the steps he's going to take if he needs to do this. If the publicity becomes too great from only allotting so many people to go into the courtroom, only allotting one local journalist to be able to be talking about the case. I mean, he's gone above and beyond to make sure that what he's talking about, what's going on in that trial, is not leaked on a daily basis. You know, he spoke about it last hearing.
The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads.
See, I think that's going to be the huge point right there, that she didn't give a contingency plan on how they want the continuance to go. Like, hey, Judge, we're asking for 60 days, and this is what we're going to be working on in those 60 days. to get up to speed so that we can get to trial at the time that it's needed. I didn't hear any of that stuff. I don't know if I didn't just hear it or you guys heard it, but let me know exactly what you think, you know. Do you believe that she could have done a better job at a contingency plan presenting it? Most of her arguments apparently they seem very emotionally connected, emotionally based, not so much on the law part of it. Hey,
Leads me
Midwest.
to, I think, the other point that Ms. Taylor raised, which was to say that, this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense, until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record.
You're so right. You're so right, Farrah. I didn't catch that the first time. It's like, oh my God, this guy's on point. They got a superstar up there. Brian looks a little stiff today. What's going on, Brian? Didn't stretch?
And ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say, we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuation.
Yeah, someone said his name was Josh. So I don't know what his last name is, but I remember hearing about him. He hasn't really spoke in the last 2 hearings, but it's good to hear him talk. I mean, he seems like he's very knowledgeable on his stuff, and he's He's not really aggressive, and by no means, none of the prosecution has came across as aggressive or mindless or any of the stuff that is repeated on these YouTube streets just because they have disdain toward the state. I mean, they have a job to do. This guy has been suspected of 4 murders and a burglary. They have a job to do. To pin these two sides against each other is just for theatrics. To pin the judge against Kohberger is just for theatrics. You really think the judge is up there looking at Brian going, God, I can't wait to sentence him or till he gets sentenced to death. Do you really think, honestly, professionally, ethically, he's doing that? No, he's not. I mean, to hear all these things that are said about these people, it's just ludicrous sometimes.
Continuance, and to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
I believe that was presented well. I don't believe that he went outside of any guidelines. There wasn't any kind of, like the judge said, there wasn't any kind of theatrical going against the defense, any of this stuff. And honestly, to be honest, on the defensive side, Ann hasn't really done any of the stuff that she did in Latah County in a while. She has stopped with her theatrics. Now she's gone to the solemn, almost sad mother sympathy card to pull on the judge. Like, come on, judge, we need some time. She's pulling out all the stops.
Any reply?
Yes, thank you. I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records of Brian Kohberger, past treatment records of Brian Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Brian Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Brian Kohberger's full life history.
You know what? When it comes to trial, be ready to see Brian come in with some glasses and obviously dressed to the nine, because it's been a tactic that I've heard from defense attorneys in person say that they tell their client to look as studious as possible when they come to trial. Put on the glasses, get a haircut, stand up straight or sit up straight, answer the questions, in your adult voice. Don't deviate from anything if you are put on the stand. And that leads me to ask you this question. Do you believe Brian's going to testify on his behalf? Who in their right mind would put Brian on the stand, honestly? Do y'all believe he's going to testify on his behalf?
These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years
In federal court,
in federal court.
which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Koberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record.
So tell me this. It looks like the prosecution is down at least an attorney. So how have they been able to be ready with going through all the evidence, putting it all together, being ready for all these hearings, responding to every litigating factor, but the defense has not? They have as many attorneys, if not the same. How are they not able to be more ready? That is my question. Do y'all have any insightful answer for that, chat? Let me know what you think.
Court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Koberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
Okay, I'll give you that. Oh, nice.
All right, I'll take the matter under advisement and get an opinion out in short order. In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated. All right. Is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
Your Honor, I don't believe so.
All right. We'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session.
I mean, he's never stated anything like he states everything like that, but he always tells you a little bit like, well, you know what, I'll take it under consideration, but this is what I'm really thinking. Were y'all able to catch my DoorDash driver video today, or y'all want to watch a little bit of it? Because I got to get to the gym about 9:30, but I can play a little bit of it. If y'all want to watch that, can you put a 1 in the chat? I mean, we're going to watch it regardless, but I'd like to get your input on it a little bit. Because I'm talking about a little bit about what Ashley Banfield and what Brian Enton are talking about. So let me know. Sure, why not? Okay, play it. Let's watch it. All right, you're on it. Awesome. Why'd you put a 12? I said a 1 or a 2. That's funny. A 12. I guess that means yes. All right, let's watch it. I gotta set this up better. I don't know why I just don't put that as my default. Here we go.
Away from the opening statements in the Idaho quadruple murder trial. And if you thought things couldn't look any worse for Brian Kohberger with, the DNA and the cell phone data and the surveillance video and an eyewitness description of his eyebrows, at least, not to mention the laughable alibi, I like stargazing at 4 o'clock in the morning with my phone turned off. I know, I kind of thought that too, until what I heard today. A smoking gun that both sides somehow managed to keep under wraps for months. There is apparently another eyewitness. It's the DoorDash driver who delivered food to Xana Kernodle less than 10 minutes before Xana and her boyfriend Ethan Chapin and Xana's housemates Maddie Mogan and Kaylee Gonzalez were all savagely murdered by an intruder. Police have confirmed to us that a woman seen in some of the interrogation footage from an unrelated incident is a 43-year-old woman known only as MM in the court documents. She was arrested that day for a DUI while being questioned at the Pullman, Washington police station. Just happened to reveal to the officers that she had to, quote, testify in a big murder case here because I'm the DoorDash driver.
And I did a video on this probably Saturday, and there's a lot of individuals that have that bias, and they'll always have that bias. You can't convince people of certain things that they're unwilling to see or change their stance on, and that's fine. They'll have that bias on there's no way that this could have happened because of this, because they don't look any further than their last recollection or memory of what they know about certain things. Well, I'm about to show you. Let me take Ashley down and let me put Jeff back up. What I'm about to show you is, we all know, you are cracking me up. I'm going to play this. You are cracking me up about that blouse. That's her news. What'd you say? It's her News Nation uniform. You are going to get together and send her a new blouse for her lives on News Nation. That is hilarious. You are cracking me up. So y'all don't like that cream? I never even realized that. Y'all don't like that cream colored blouse of hers, huh? that Xana got her DoorDash at what? 3:59, right? That's supposedly the time that the DoorDash driver dropped off Xana's order. And if this lady is indeed the DoorDash driver, then there is a way that she could have seen Brian. I think where people are getting mixed up in all this is the semantics of what she said. I parked next to Brian. Well, parking next to Brian does not mean I pulled up next to Brian and parked next to him. She could have already been parked. And my mouse just went crazy. Of
Yeah,
course.
my mouse was
Just
going
like everything
bonkers.
else when they're trying to show something.
I did this at
So she
4:30 in the
says,
morning.
I parked next to Brian. And many people think that that means,
You hear me with the mouse?
like I just said, that she pulled up next to him and parked, which in reality is not true. It's all the way you word things. And you say, well, 12, you just want to word things against Koberger. You want to make him guilty. No, I don't. I want to show, just like everybody else, that quote unquote evidence.
I do too.
Well, look at this next. There's 3:30, there's 3:39, and then we're going to have the next important passing, which is 3:56, 52. And then we have 4:05 and 4:07. So at 3:56, and the DoorDash driver delivered the food at 3:59. And as you see there, you say there's no way that this individual could have done this. There's no way that she could have seen him. And I tell you there is.
That's more 4:30 in the morning, boys.
Not based on what I believe, not based on what I want to think, but based on what these cameras are showing. If this is indeed his vehicle, which I believe it is, in my opinion, then as he's driving by at 3:56 to go around the Queen Road Apartments, if she pulls up at 3:57, 3:58 even, then that's plenty of time for him to get around those apartments, come back down King Road, and creep by her as she's already parked. Because something must have happened in order for her to say that she parked next to him. What does that really mean? Does that mean that he slowed down enough for her to feel like he was parking next to her? Or what would have happened? What could have happened? And I don't like those coulda, woulda, shoulda things. But let's use your critical thinking skills here. Let's say he does pull up slowly off King Road on the side of the house. Okay? Let's say he does do that. And she's parked already in front of the house. if he is creeping by her, because there's not that much room between the front of the house and that drop off where those stairs are, he would be creeping, right? If for no other reason than to not hit that tree in front of the house or the dumpster. So he would have to barely creep by her. Is that not true? Of course it is. So for people not to believe, and they want to say that this woman's eyesight is all of a sudden bad because she has had a history with drugs or alcohol, or even on that getting pulled over for DUI. All of a sudden, these witnesses are unreliable at trial because their eyesight automatically gets bad, right? So I believe at that 405, what made him come back around was the fact that that's where he did a 3-point turn. That's why 407 was the next sighting of the car. So 356, he passed that vehicle. I have to look at the PCA, but I know that he did a 3-point turn on one of those passings. It's either 356 or 405. One of those he did a 3-point turn. So if he did a 3-point turn, obviously he was heading west on Queen, and he would have potentially went right next to the DoorDash driver. So all of a sudden she has bad eyesight because she got pulled over for a DUI. All of a sudden she has a bad memory because she got pulled over for a DUI. All of a sudden, just like Dylan, because she was in and out of a drunken haze, she has a bad eyesight, bad memory, bad recollection of what was going on. People really never cease to amaze me when they're thinking like that. It's kind of like, you know, a prostitute gets attacked. And since she's a prostitute and a drug addict, her eyesight is bad, her hearing is bad, her recollection of her environment is bad. You know, I understand it's the defense's job to discredit the witnesses. I get that. But why must we always add to that narrative? Because if it holds true, then how come we can't use Brian's past drug addiction against him without people getting mad? You get what I'm saying? Because people do get up in arms when you mention the past heroin use or any of that. Well, he's no longer a heroin addict. That's when he was young. Okay, well then this lady gets one DUI, and obviously she's had some trauma in her life that she's dealing with the best she knows how, and you're crucifying her ability to recall anything because she could have been high. And as we learned last night, trauma is not what happened to you, but what it does to you that night while she was out delivering DoorDash. Could have been. Just like Brian could have been high before he committed the crime because he was a past addict. Do you see how that works?
End quote. When the officer asks which murder case, the woman says, quote, the murder case with the college girls. I'm the DoorDash driver. I saw Brian there. I parked right next to him, end quote. And I think I need to read that last part again because I did a double take when I first saw it. I saw Brian there, she says. I parked right next to him. That interrogation video was posted on a YouTube account where it was discovered by Web Sleuth.
So if she parked right next to him, like I said, she could have already been parked. He's slowly creeping by her, or he's creeping, and she parks just as they pass. You know, it's easy and culpable to happen. It really is. But it's based on how you look at the case. If you look at all the circumstantial evidence and you want to throw it out the window and say that there's no way that this could have happened, then of course there's no way it could have happened in your eyes, because that's your bias. Do I have bias? I have bias toward wanting to see this case get on with it. I have bias in wanting to see whether this man is indeed guilty or innocent. And I have bias in getting justice for the 4 murdered kids that night. Do I care whether Brian was cruising by, whether he was idling next to the DoorDash driver, or she saw him in passing? Do I want to focus on the semantics of the wording? No, I don't. But it does bring about the juiciness, right? Because we are going to have a continuance hearing today. I don't have to pause this because it's my own stuff, but I want to say this before I forget it. You know, people have been dogging Dylan for a long time because supposedly she was deleting videos or downloading videos or photos or whatever. Did it ever occur to anybody that possibly Dylan could have taken photos of Brian out her window, or maybe even a video of Brian going to his car? Have y'all ever thought about that? Maybe those were the bad, blurry photos that she took of him, and she was getting to the good photos. Just a thought. I know this is speculating, but just a thought. And I've said that before eons ago. But have you ever thought maybe her or Bethany took a video of Mr. Koberger out the window going towards his vehicle? Or maybe even took photos of his vehicle? You know what I mean? What do y'all think about that? Is this going to play any?
Journalists. It's unclear, though, whether the woman's outing will affect the start date of the trial itself. The defense has been pushing for a delay for weeks now, but that's over the media leaks, the whole Dateline episode kerfuffle. And that is due to be the subject of a big hearing tomorrow. But the prosecutors want the trial to stay on target for the planned August 11th beginning. Our senior national correspondent, Brian Enton, is in Boise, Idaho tonight with much more on what all of this means. First of all, I did not see this coming. A second eyewitness.
Yeah, this is a bombshell, Ashley. If it is true what this DoorDash driver is saying, then this is a bombshell. I came to Boise thinking that the hearing tomorrow was going to be the big story.
Because if you believe Dylan, which many of you don't, then her testimony would put him in the house. And then if you believe this woman, which many people don't now, then she would put him outside the house. Two eyewitnesses IDing the same type man. One able to identify the vehicle. What makes you think that how they were able to be on that vehicle so quickly? Because she ID'd it. She was right next to it. Well, many people, PKC, they assume because she got the DUI, then she's a drug addict, she's a junkie, she's a dope fiend. They're already calling her different names. You know what I mean? It's kind of like the age-old adage that if somebody dressed provocatively and they get raped, they were asking for it. Because if they would have been dressing that way, then it wouldn't have turned on the rapist enough to want to rape her. It's that old school thinking. It's that old looking at the lens of reality on what you know rather than being able to look outside the box. And even one of the persons that I saw that was talking about this, and that's what I like about this chat, especially right now tonight. There's a lot of people able to look outside that proverbial box. You're able to ask those questions, and many people, when they're asked those questions, don't have answers for. But they get upset, they get angry, they want to fight, they want to get aggressive, they want to do this and that and the other. But you know what? I'm digging it. I'm digging it. Keep the comments coming. You are doing amazing. Claims to be a very educated person, but yet he sounds really ignorant when he comes across with his statements on this DoorDash driver.
Story, but this is big. The Idaho Statesman was the first to break it today. Basically, this DoorDash driver, who we knew existed, by the way, we've known for a long time there was a DoorDash driver, that she goes by MM. She's been referenced in the court documents. We knew that she arrived there to deliver DoorDash at 4 a.m., about 10 minutes or so before the murders. But what we didn't know is what is in this body camera video. And let me explain this a little bit. You did, Ashley, but the reason we know about this is because last year, this DoorDash driver, totally unrelated to the Brian Koberger case, she got pulled over, suspected of driving under the influence. She had a expired tag, suspected of being under prescription pills, and she got pulled over, and she just started volunteering this information to the police while
Me
she was
too.
being interviewed, and it's on body cam. And she said that she's the DoorDash driver.
And people say, I'm not defending this woman, okay? But people say, look, she's high as hell. Well, of course, she admitted taking a hydrocodone and a Sudafed. You know what's in Sudafed, right? It's one of the components of how and what goes into methamphetamines. So if she's under hydrocodone for pain of her arthritis and everything, of course she would look, her eyes would be glazed over and all that. But once again, people want to call somebody a dope fiend because they're getting pulled over for a DUI. That's interesting to me. And a lot of people have done it. She's a junkie. She's this. She's a meth head. Okay. So do you not want her to be a person of that? I don't believe she was high. I'm just repeating what I've heard people pound into the pavement. And I don't believe she was high. I believe that if anything, she suffers from PTSD, depression, the loss of her husband, trauma, all that stuff. Not to mention the fact that she escaped with her life by that much. A couple seconds less, or a couple seconds that it took her to get there and Brian was already in the house and she was delivering and he heard her. I mean, who's to say what would have happened? But, you know, she saw an individual who committed a quadruple murder in her eyes. How would y'all react later on knowing that you were there at the house minutes before something that tragic went down? That's two tragic events in her life. Could identify the killer of these four kids? Or is it more important to you her character? Because to me, what she does on her own time, just like many of you say, what I do in my own time, my business. Okay, well, what you do in your own time is your business. But if you were to see something happening, you see a crime being committed, all of a sudden, people want to take into account what you do on your own time as a character flaw.
No, she's not.
So I ask you.
Hold on, Leslie. She is not still in jail. This happened in 2024. How could she still be in jail in 2025? Where did you hear that? Leslie, where did you hear that? She's not in jail. Jesus. Leslie.
Enough with the double standard. Is she going to be high in court? Of course not. How can you be even subjected to that kind of scrutiny unless you have a history of it? You know, she had that one prior DUI. How many of you have ever been in trouble with the law with multitudes of other charges? And yet you don't want to be linked to those charges today because time goes on and people change. If that's true, then how did this woman get chastised, ridiculed, and pigeonholed into being a junkie? I'm asking logical questions, aren't I? I'm not trying to be facetious. Aren't these questions logical? Because a lot of people would be pissed off if they were being treated like this woman is and what's being said about her. Like I said a long time ago, if your life was caught on camera, like a lot of these individual lives are because of this high profile case,
Yes,
how
I
would you
heard her.
like the scrutiny of the public based on one moment in time when you were not at your best and you made a mistake and you ended up being questioned for it? All caught on body cam.
Leslie, I'm not going to show it if it's on somebody else's channel. I'm not going to promote anybody on here unless it's somebody that I find reputable, you know?
For the same people that are judging and condemning this woman are the same people that cannot see the possibility of Brian being able to kill these people and be the killer. Where there's much more evidence in that than there is in just a 3 to 5 minute video. But you're basing your whole knowledge on what you know on a 3 to 5 minute video on this woman,
From the Brian Koberger case.
on this woman potentially being a junkie. Yes, she does. She does.
There's
But just like
PKC.
everything else, people are quick to judge instead of quick to have compassion. Her DNA was then found on the knife sheath under Maddie Mogan. Koberger's was. So when she says she parked right next to Brian, the semantics parked, pulled up, was in the vicinity, and what she saw, people say, did she have eyes in the back of her head? Was she able to look behind her while she was looking at Brian? You moron. Does your head not swivel? Or is your spine fused together where you have to move your whole body in order to see behind you? If that's the case, then I retract my moron statement. But most people can move their head and swivel it from side to side in less than a second and see exactly what this man is looking at. She said he was unable to break his trance-like state based on something that somebody read. Whether that's real, whether that's not, that's what I'm going that based on. So I'll quit talking about that because that's obviously not been vetted. So, yeah, exactly. People don't have compassion for victims unless they're painting themselves as a victim. Oh, Jesus, Leslie, I am definitely not showing that video. Not with that creator. No, ma'am. I'll watch it, but I am not showing that video. No, sorry. I love you, but not showing it. That's the only time that they want compassion. But like I said, you instantly want to paint this woman as a junkie, unreliable. But the same people that are wanting to paint this woman in that corner cannot possibly see. You know? Well, I get that, and that's what somebody just said in another live. So I get that, Alexia. I get that. I heard that in another live a couple minutes ago. But we don't know this woman. That's on assumption that she's a dope fiend. That's on assumption that she's a junkie out there on the street selling information for dope, which we don't know that that's the severity of her hydrocodone usage or anything else that she's using. My point of the matter is, most of you smoke weed, right? But you get upset and angry when somebody judges you for it, when they assume that you can't take care of your family, when they assume that you're just the same as a person shooting up by a dumpster. Do you see the point there? We don't know what this lady's life was like. We know 3 to 5 minute video. You know what I'm saying? So whenever somebody judges you for your recreational use or whatever it is that you're using, why would you get mad if they have that prejudgment on you, but yet they don't know you, right? They don't know your business. They don't know your life. Then why would you judge this woman so harshly when all you know is 3 to 5 minutes of her life caught on video? You don't know other than, her husband was murdered in front of her. She has health issues beyond belief. And I made a mistake on this video. Her husband was murdered in 2013. I later looked that up, and I made a mistake on this. So, but that would have been if she would have had drug issues. She would have been in and out of jail since 2013. Don't you believe? But that's not enough for you to realize that if she uses hydrocodone lately for the pain, or every 6 hours or whatever, then that makes her a junkie. Sudafed to be able to not breathe. How many of us take antihistamines to be able to breathe clearer? A lot of us. Would it piss you off if you told somebody, hey, I took a hydrocodone for my back today and some Sudafed. So if I'm acting a little loopy, that's why. Well, you're a junkie. What? You get what I'm saying? It just weird. It's just weird to me how quick people judge based on a video as if they know her whole life, especially tagging her with such discriminatory labels. So everybody out from 3 to 5 in the morning is either having sex or getting high, according to this person's mentality. Well, I disagree. Some people are up getting ready for work. Hell, I'm up at 4 o'clock. I'm not getting high. I'm not having sex. I'm not going around committing murder. None of that. So to use that absolute as everybody, that's that's not cool, man. Not cool. But you be you, I'll be me. Yeah, exactly. It's hard to believe this video's been out. But nothing's coincidental. Everybody pushes a narrative. You ever notice the closer we get to these hearings, there's always something huge dropping, and they're always blaming the prosecution because we got a little bit more to go. I hope it's not boring you. I hope you're enjoying it because I'll make some more points here in a little bit. Because it never looked good for Brian. But who's asking for the continuance? And I'm not blaming the defense, but who would have more to gain? Who would have more to gain by discrediting this witness? If the prosecution has been trying to hide her identity all this time, and all of a sudden this video gets dropped and her livelihood and everything about her is in question, isn't that trying to already try this trial in the public forum, which it seems the defense attorney wants to do that? Let's watch a little more.
Is that she saw Brian Kohberger, which is really the headline here, that she's a witness who saw Brian Kohberger, and all of this just happened to come out through this new body camera video from Pullman, Washington.
So, Brian, you take us back to the house, but we're going to have to describe it because the house has been torn down. But if you look at the front of the house, there's a parking lot out front where all the cars were lined up, and they stayed that way till they were all towed. But this DoorDash driver said, I parked next to him, which makes me wonder if she's talking about the parking lot out front, or if she's talking about that side street off to the left where that bushy tree is, that big tall bushy tree is, just adjacent to the red car there. Because there's this.
You see the whole semantic, the wordplay? I mean, they're even doing it. It makes me wonder if she could have parked on the up by the trees, delivering the food in the backyard. And then they go to say, well, most DoorDashes that I've had, they deliver in the front yard, which is right. Most do. So why would she park along the tree line? She wouldn't. Like I said, it's all the wordplay. It is a bombshell. I'm not saying it's not a big deal. I'm not saying that at all. I'm not liking how she judged based on what she got pulled over for. You know what I mean, Alexi? I'm not saying it's not a bombshell. I'm saying that the fact that people are trying to discredit her before she even takes the stand It's what's wrong with this case. People say there's so much craziness and so much unbelievable stuff, but people make it unbelievable. Even what she just said. Why would she park along the tree line? Is that what she meant? She parked next to him? Well, let's use your brain a little bit. And you know what else I didn't think of this morning? I'm sorry to make this so long-winded. Um, and all of you that are struggling with present or past health issues, I'm glad that you're doing what you need to do in order to have quality of life, because it's not always easy to take pills. I know it's not. But this is what I wanted to say. When I've had DoorDash delivered to my house, DoorDash usually takes a picture by the door to show that they delivered your food. Somebody made an interesting comment in the chat. What if she had a picture of Brian? What if she got a picture of the car that kept driving by? What if she got a video? They are tough in this chat, man. Yeah, and taking care of our parents is a challenge in the best of circumstances. You're right. You are right about that. You're right about that. Thank y'all for sharing your experiences because it makes it real. You know what I mean? It makes it real. Because most people act like they've never been on pain meds whatsoever. Like they've never been on hydrocodone. They've never taken pain meds for injuries, car wrecks, anything like that. You know what I mean? Yeah, I saw that. PKC, you were up with me this morning. I was shocked to see you up that early. Let's continue on. We're almost done, guys. Hang with me. Ashley, there's more room in the front of that house to be able to park off the road because you don't want to get hit. So it makes more sense to either pull in the driveway or pull alongside the driveway and park in there. You wouldn't do it on the side street because there's cars parked along one side of the street, which I don't believe Brian parked next to those cars anyways. I believe he parked further back and walked up. You know what I mean? I don't believe that he parked alongside the house like many people believe. I mean, they make it sound like he parked, left his car idling, jumped in it, took off. No, I believe that he parked further up. He was a runner, so he's able to cover distances quite quickly. So it wouldn't have taken him no time to get back up there and be off and running. So, it just not really annoying because you have to have some emotional connection to something to be annoyed. I don't have an emotional connection to this. It's just the understanding of how people use people's mindsets to kind of govern which direction they want you to think. This whole interview is kind of like that.
The side street that goes up that left-hand side of the house, and isn't it?
Yeah, it's a very
that the killer used. Yeah, walk me through that.
Sorry, I didn't mean to interrupt you. There was someone talking in my ear. Yeah, it's a very, very important part of what she said. Not only that she said, I saw Brian Koberger, but I wrote this down. She said, I parked right next to him. Now, you think about DoorDash. We all order DoorDash. A DoorDash driver typically would park right in front of the house where they're delivering the food. They pull into the driveway. You see them in the driveway. They get out. They go to the front door. They give the customer the food. Why would the DoorDash driver drive onto the side street of the house, which with the murder house, you've got the front of the house, you've got the driveway like you described it, but then you've got this side road that goes up the side near an apartment building. You can't even walk down to the house you'd have to go through the woods unless you walked all the way around if you went to the side road. We don't know exactly where Brian Koberger parks, if he's guilty of all this. They've never said.
And they continue doing this whole semantics thing. I'm not going to play that whole video. It's on YouTube if you want to go and watch it. It dropped probably about, I don't know, a couple of hours ago. But I'm going to play Jeff's video again. That way y'all can see, the ones of you that just came in here, the passes, because he did them in sequence. There's one at 3:30, 3:39, and the one that people forget about is the 3:56, 4:05, and 4:07. Like I'm saying, that 3:56 one, by the time he gets around the Queen Road Apartments, if she's delivering the food at 3:59, that could have been the pass and what she's talking about. He went right by her. You get what I'm saying? I don't believe, anything after that would have been too much time unless she herself turned around in the driveway and then Brian was coming back down at 4:05 and they passed. See, I had forgotten that the 4:05 was the one where he pulls in, backs up, and then goes back down. If she was, turning around, somebody said in the chat that she sat there for 6 minutes. Is that what y'all said? So if that's true, then either one of these she would have seen him, 3:56 or 4:05. I also surmised that, what if the DoorDash driver, I don't like to use the what if, but possibly the DoorDash driver could have been in front of Brian or behind Brian as he left the neighborhood or was going to make another turn around. But I don't think so, because I think at one of these he does the 3-point turn. So if she was in front of him, that would make sense that if she was in front of him and he made the 3-point turn and then came back around on this last turnaround around the Queen Road Apartments, and then he parked and did what he did. 4:07 would definitely be too much time, but 3:57 to 4:05, right? That range. Possibly so, Alexi. I mean, she's had, I don't know that she became a drug addict. I mean, are you really a drug addict if you have extreme arthritis and you're using medication to manage it?
I don't believe
I mean,
so.
does that make you a drug addict? It's kind of like people, I don't smoke weed, okay? So it's like people with um, medication cards that smoke weed for, all kinds of pain. Are they drug addicts because they're smoking weed? Hey, Walt, I'm just asking questions. I'm not coming at anybody. You get what I'm saying? It's early in the morning. This is my early morning voice. So that's my whole point is I don't believe she was a drug addict. I don't believe that her statement should be scrutinized as much as it is because of one incident caught on video. If anything, the defense is probably, if this does make it into the trial, the defense is going to try to discredit her, just like they're going to try to discredit Dylan. But you don't think the jury's smart enough to think, well, they're trying to discredit this person for a reason? Do we really want to focus on Dylan being drunk and unable to, go in and out of consciousness through every time she opened the door? Is that going to really matter to us as much? So is this DoorDash driver, is her in and out passing with Brian that one time gonna going to be enough to give us reasonable doubt that she could have been under the influence. You cannot really go on somebody's past based on their current state of mind. You can't. You can't say that, okay, well, she got a DUI a year or 2 years later. So in 2022, whenever she was delivering food, where was her state of mind then? Her husband wasn't dead. She hadn't experienced all that trauma. She was out delivering food. See, that's when I made the mistake. Her husband did die in 2013, so that's why I was correcting that. You know, there was no DUI that night on her delivering food. We got about 5 more minutes and then we're done. I'm about to make one more point. Where are the positives for this? Everything has to be negative. One more time. 330, 339, 356, 405, 407. No, I haven't, Leslie. Yeah, drunk Dylan. And did you see that 406 one? That car was going back the other direction. I've never noticed that. Y'all cut me some slack. It was 4 in the morning, 4:30. Here, I'll speed it up just a little bit. And if you want to know who Leslie sent me, she sent me that lady who lived down by the river. I love cats. Yeah, I had to use a 10 unit. I never thought of this, but it does make sense why he went around the house so many times like that. If his eyesight is bad, here we go. As they've said, it would be easier for you to get a good look through the driver's side window rather than trying to look out the passenger's window. Because if you're out trying to look through the passenger's window, you have the propensity to run into something. So it's a lot easier to cruise by looking out the driver's side window. So that makes sense why he made so many passes and went around the Queen Road apartments in front of the King Road residence. That does make a lot more sense. Because you can see the house as you're passing it through the passenger side window going up around Queen Road. But it's not a clear shot because you're paying attention to your driving. So as you're rounding Queen Road, it does make a lot more sense to come back down that side street. You get the visual through the driver's side window. You can look in the back, make sure the lights are on or off, and then you cruise through the front and make sure the lights are on or off too. Oh man, why didn't I ever put that together? Let me know what you think about this video. You don't have to agree with my hypothesis or any of the statement that I made, but I'd like you guys to kind of lighten up on the DoorDash driver. She obviously has gone through a tough time, just like a lot of people in this case. You know, the person that people want to be innocent, he's gone through a hard time, and people can see that. But they can't see how these other people have had tough lives as well, and they want to crucify them. Okay, I hope y'all enjoyed that video. I was doing the head nods. I was driving by, you know, like looking in, looking up at the back of the house, looking and seeing, and then cruising around. looking by, not really paying attention to the DoorDash driver. That was my theory. That was my big breaking moment. I have a lot of those. You know what I mean? So it's always nice to, when I have those, that I share those earth-shattering moments with you guys. And you're probably like, come on, 12. We've thought of that a long time ago. Well, sometimes it takes a lot more to get into this concrete head of mine. But I hope y'all did enjoy that. I've had fun tonight with you guys. Thank you so much for the chat. You guys have been amazing. The comments, the humor. I love the humor. I love it. You know, some of you make the chat very interesting with your humor. You say, was it you? You sure know a lot about this case. Oh, yeah, you got your degree. To a lot of people, that degree doesn't mean nothing, Leslie. It's just a piece of paper. They're smarter than I am because, you know, what's a degree? She does live out of her car with her cat. She does. That's what I've heard. I love cats. I mean, you know, nothing against the cat. But, you know. You know, sometimes you gotta wonder about the person that, you know, is bringing the material. But like I said, I'm about to head to the gym and I'm 5 minutes late. So hope you enjoyed it. Hope you like my new outro. Y'all leave some comments, hit the like button, subscribe, and share if you like. To those of you on X, come on into the chat, the friendly place. You'll fit right in. Till next time, everybody. Maestro, cue that music.